Back on the record in case People versus Brandon Martin, RAF 1506112. Mr. Martin present with both counsel. The people are present. All members of the jury and alternates are present. Mr. Beecham.
Thank you. Good afternoon.
Good afternoon.
Doctor, before we broke, you mentioned that there was some sort of incident that took place in March of this year with regard to Brandon Martin. Do you recall that?
Yes, I do.
Okay. So tell us about that. What is your understanding that happened? What happened?
Well, I think I mentioned that in the context of why the jail didn't pursue an involuntary medication order when they had clear evidence of Mr. Martin needing control.
That wasn't my question. My question is specifically with regard to the incident. Tell us about the incident.
Mr. Martin had an altercation and involved the deputies in the altercation and was brought back to the jail where he was seen by a psychiatrist or clinical technician.
Okay. And that was a physical altercation, is that correct?
Yes, that's my understanding.
Okay. And then when Mr. Martin was asked about that physical altercation, his response is he didn't recall it, correct?
Correct.
His response wasn't, well, you know what, I had some command voices telling me to be combative with the deputies, correct?
That's correct.
You didn't say that, I don't know what you're talking about. I thought I was in an MMA fight or a mixed martial arts fight, correct?
That's correct. He has never really offered much in the way of explanation of his behavior based on command hallucinations or delusions.
Well, going back to the actual facts underlying this case, did you listen to the guilt phase?
No, I did not.
Okay. So do you know what evidence came out in the guilt phase?
No, I do not.
Didn't read any of the transcripts of the guilt phase?
No, I did not.
Okay. You know generally what this case is about, though, correct?
Yes.
That Mr. Martin, after he left ETS, got on a bus, right?
Yes.
Okay, and then took the bus to Corona, correct?
I think
not even know
he took it to the Tyler Mall and then walked home.
Well, he got on the bus at Tyler Mall to Corona and then walked home from Corona.
Oh, okay. My mistake.
All right. Were you provided the bus video by
No.
defense? So you didn't review the bus video, correct?
Maybe I'm not understanding you.
When Mr. Martin was sitting on the bus,
yes.
There's video. There's a camera on the bus. So there's a 45-minute bus ride with Mr. Martin, right?
Oh, I don't know about that. I don't know anything about a video from that bus ride.
So you don't know if Mr. Martin was talking to himself on the bus, correct?
I don't know anything. Or
if he had command hallucinations on the bus, correct?
No. If I've never seen it, I can't know anything about it.
Right, but this would be important information for you, correct?
No.
Are you saying that if Mr. Martin was making an outburst on the bus saying, these demons are trying to make me kill people, that wouldn't be important for you as a psychiatrist to know just, an hour before he commits these crimes?
Objection. That misstates the evidence in the guilt phase. Overruled. You may answer.
If I was hired in this case to assess whether Mr. Martin was not guilty by reason of insanity, that would have been absolutely essential in terms of informing the jury about the nature of schizophrenia, its treatability, why Mr. Martin has not gotten treatment. It's irrelevant whether he was or was not insane at the time, given I was not asked to investigate that.
Right, but would you agree that since we're in the penalty phase, how prevalent command voices that Mr. Martin had would be something that the jury would consider, right?
I don't know. Is it your thought that people who have schizophrenia with command hallucination should be killed, but people without command hallucinations should be given LWOP?
Well,
That would be nonsensical.
well, that's for the jury to consider, right? Like how prevalent these symptoms of schizophrenia that Mr. Martin had, correct? Especially at or near the time of the killing.
Well, my understanding in this phase is treatability and effectiveness of treatment is far more important than whether a person should be killed because of past symptoms that were untreated.
Do you know what factor D is in this penalty, in a penalty
No,
case?
I don't.
Okay, but you're a lawyer, right?
Yes, I am.
Have you tried any capital cases?
I've been involved in well over 100 capital cases.
Okay, so you've presented evidence either as a prosecutor or defense in well over 100 capital cases.
Yes.
Okay, were you a prosecutor?
I don't practice as a prosecutor.
Okay, so you were a defense attorney in well over 100 capital cases.
No, I don't think that's what I said. I've been involved presenting psychiatric information in over 100 capital cases.
How many capital cases have you tried as an attorney?
I've never tried any capital cases as an attorney.
So is that why you don't understand what factor D is?
No, it's because I testify in different states and they have different regulations for what's aggravating, what's mitigating. So I don't know what California's factor D is off the top of my head because I haven't been involved in a capital case in California presenting mitigation evidence in many years.
So do you not know that the entirety of your testimony here today is for factor D?
You seem shocked. I'm here to present psychiatric information to help the jury make their decision between life without parole and death.
Because insanity is not relevant in this phase, correct?
Insanity is an issue during the guilt phase, or the insanity phase as part of the guilt phase.
Right. So there's a guilt phase, correct? There's a guilt phase in every trial, correct?
Most of the time, sometimes it's stipulated to, but that's still called the guilt phase.
Okay. So there's a guilt phase in every trial, correct?
Sure.
Okay. And then after a guilt phase, there's either the insanity phase or penalty phase, correct? If there is a second or third phase.
Yes.
Okay. And so we're not here in the insanity phase, we're here in the penalty phase, correct?
Sure.
So whether Mr. Martin was insane, well, that's already been determined, correct?
I don't know. It wasn't tried.
Well, we know who did it, right? We know who did it.
Mr. Martin's been found guilty.
Right. He did it, right?
He's been found guilty, yes.
Okay. And we know that it was premeditated, correct?
That's the jury's finding that led to the guilty verdict on first-degree murder.
With deliberation, correct?
Yes.
And it was willful. Yes.
All the mens rea factors for first-degree murder, yes.
Okay. And so we're not now in an insanity phase, correct?
Who thought we were?
I didn't say anybody did. I'm just saying, is that correct? We're not in an insanity phase.
Objection asked and answered. Relevance. I think it's been asked and answered. Sustained.
All right. So marijuana. Can somebody have acute psychosis by ingesting marijuana?
Yes.
And what are the symptoms of that acute psychosis?
Typically very extreme anxiety, claustrophobia, and paranoia.
Cocaine psychosis. What are the symptoms of cocaine psychosis?
Paranoia, what's called formication, the experience of parasites or insects crawling under the skin. It can involve visual or auditory hallucinations, but rather short-lived.
LSD psychosis.
Often involves both strong elements of visual hallucinations, visual distortions, auditory hallucinations, and can include both grandiose and paranoid delusions.
What is chronic marijuana abuse? What are the symptoms of that?
As I think Dr. Valku was trying to explain, that is not current terminology. The DSM-5, which was sort of adopted by most clinicians in about 2013, has substance misuse divided into levels of severity, whether mild, moderate, or severe, depending on how many disabilities or how strong the untoward consequences are. The distinction between abuse and dependence was not workable, particularly with marijuana, because there is no physical dependence on marijuana that is verifiable. There are cravings, but it's not clear that the cravings are physiological.
It's more of a psychological dependence?
Well, people use the term cannabis abuse to mean that they, the clinician, thought it was unwise to use marijuana, and use the term cannabis dependence to designate that they thought it was very unwise to use marijuana.
So what are the symptoms of marijuana abuse?
I'm sorry?
What are the symptoms of marijuana abuse? If you were to
what were they under the DSM-4 that no longer are considered current terminology? Is that what you're
Let's
asking?
go with DSM-5.
Okay, so DSM-5 doesn't use that terminology.
Okay. So there are no symptoms for chronic marijuana abuse?
There are symptoms for misuse of marijuana, and those are graded from mild to severe.
What's the difference between misuse and abuse?
Because abuse in the DSM-4 was more subjective and was thought to be the use of marijuana that was somewhat harmful.
Okay, so what are the symptoms of marijuana misuse?
Of marijuana misuse?
Yes.
Is you need to have 2 or more of a listed set of criteria, which include not taking personal responsibility for your health, not taking personal responsibility for your finances, not taking personal responsibility for the safety of others, having cravings, having spending more time thinking about the drug than you intend to.
So on direct examination, you talked about you didn't know if Mr. Martin was under the influence of marijuana at the time of the crimes that he committed, correct?
That's correct.
Okay. And did you know that there was an officer that testified in the guilt phase that said that there was no indication that he was under the influence of any drugs at the time that he took him in for the ETS hold?
Am I supposed to say something about the ability of a person to eyeball someone and know if they used marijuana? I'd say it's very low.
Okay, or any other drugs. I mean, that's what a drug recognition expert would do, right? They would...
Well, unfortunately, the drug recognition expert textbook mostly has to do with marijuana, with alcohol and methamphetamine. And even with methamphetamine, there is very poor correlation between the drug expert recognition and blood tests. So it works quite well with alcohol that has a very predictable impairment of the brain. I've not seen it very effective with any other drugs.
Okay. But at any rate, he goes to ETS, correct?
He went to the ETS.
Okay. ETS, there's no reason why ETS would give him any drugs, right? Illicit drugs like marijuana, cocaine, LSD.
That's correct. Obviously some people sneak drugs in, but they use it for themselves. They don't give it to other people.
Okay. And when Brandon Martin was released from ETS, there's no reason why the ETS people would give him any illicit drugs. Just the...
I would be shocked.
Okay. And then you know that, according to the evidence, Mr. Martin went from ETS and he walked to the bus stop and then was on the bus ride to Corona, correct?
Yes.
Okay. And then he walked from the bus stop in Corona all the way home?
Yes.
Okay. Were you given Mr. Martin's interview?
Yes.
And did you listen to it?
I was not given the video, just the transcript.
Okay. So you read it?
Yes.
Okay. And nowhere in the interview did Mr. Martin say, well, I did it, but voices told me to do it, correct? Because that would show that he was insane. Would you agree?
The test for insanity is whether you know your action was wrong,
okay,
or you were unable to understand your action. The test is not whether you heard a voice, because I've seen plenty of people convicted and judged not insane when obviously they were responding to command voices. So the issue is a little different.
I understand. So just because he had heard a command voice doesn't necessarily make him insane, right?
That's correct.
He has to know the difference between right and wrong.
Correct.
Okay. For instance, he'd have to understand whether it was right to evade the police or wrong to evade the police, correct?
If he was on trial for evasion, yes.
Right. Or stealing somebody's car. And he'd have to know if that was right or if that was wrong, correct?
Correct.
If he was on trial for stealing a car.
Yes.
Or if he rummaged through people's pockets and stole their property from their pockets. He'd have to know whether that was right or wrong, correct?
Yes. Yes, of course. And that requires a different sort of examination of records and what have you to offer an opinion about someone knowing right from wrong.
Okay. And then one way to let's go back to the evading example. Let's say that Mr. Martin evaded the police. And when he was finally stopped, he said, "What are you talking about? I wasn't evading you. I was running away from demons." Right? That would be an indication whether he understood what was right and what was wrong.
Yeah,
sure.
Relevance. Overall answer will stand.
Sure.
Okay. In this case, with regard to the murders, there's no indication that Mr. Martin didn't understand the whether it was right or wrong to kill somebody. Right?
That's an open question in my mind, perhaps not in yours.
Okay. Well, he's already been found guilty, right?
Well, he did not have a trial on insanity. juries, surprisingly, sometimes find people guilty of first-degree murder and insanity.
Okay, but there was an insanity phase, correct?
There was no insanity phase, so it's an open question. That's what I was trying to say.
So it didn't rise to the level of the requirements to have a sanity phase.
Well, Mr. Martin doesn't think he's mentally ill, so that was an obstacle.
Okay, but he also said that he didn't commit the murders, right? Which is an indication that he knows right from wrong, that killing somebody is wrong, right?
I would not make that inference.
You wouldn't make the inference of him denying his guilt, right? That I didn't kill those people as whether he knew it was right or wrong?
Of course. How can you connect the two? If someone says, I don't know what you're talking about, when asked if they committed act X, Y, or Z, does that mean that they know that they committed that act with a wrongful mental state? That's absurd.
Well, what if they knew all the other acts surrounding that was right or wrong?
Well, that would come out for a jury to determine.
Okay. The emergency medical order, that's if, well, tell us about that. How does one apply for an emergency medical order?
You're talking about in the community, in a jail, or in a prison, or during...
In a community.
In a community, you cannot get an emergency medication order. You can only get it if somebody is in a hospital.
Okay.
And there is some law is law, that seems to imply that you can get one, but it seems not really possible.
So when Dr. Valcoux saw Mr. Martin, there's no indication that she couldn't get the emergency medication order?
She could not. Okay. No, because he was an outpatient.
Right, but she could call ETS.
I'm sorry?
She could call 911.
She could have called 911 if she felt Mr. Martin was in imminent, immediate danger to himself or someone else.
Now, I thought on direct examination you mentioned some sort of emergency order that somebody could apply to if they believe that the patient, if you will, could not care for themselves. Yes.
There's a court case, Reese versus St. Mary's Hospital, which describes the court's understanding of the LPS law.
I'm sorry, I should have been more direct with it. I'm talking about an outpatient setting.
California has no provisions except under the permanent conservatorship 5350 for involuntary medication, but that's not emergency medication.
Right. So there is no application, as far as you know, by anybody to have Mr. Martin placed under a conservatorship?
No, I don't see that because his 5150 was discharged.
Okay. Mr. Martin was able to care for himself. Is that correct?
Time sustained.
Okay. Going back to early part of 2015, he was able to care for himself.
I don't have that impression. I have the impression that his parents took care of him in every way.
Okay. In every way, meaning like feeding him?
Buying food, reminding him to take showers, reminding him to clean up his room.
By filing a restraining order and kicking him out of the house for weeks?
They did that, and I guess he slept in his car.
Do you know if he slept in his car, or do you know
I
that?
don't know.
Or are you just assuming that?
I thought I saw a comment somewhere, but
or did he have
I'm
an
not
apartment?
sure.
Did he have an apartment?
I don't recall. I believe the restraining order was in October 2014. You might know better. There's not much in the medical records about it, but I saw something.
Okay, assuming that he had his own apartment and he was able to get food, feed himself, provide himself for himself, that would be an indication that he could survive on his own, correct? And care for himself.
You're talking about 2014?
Sure.
It certainly would seem to be a good indication.
Have you talked to any of the treating physicians in this case?
The ones at Presley?
Sure.
No, I have not.
Have you talked to Dr. Solomon?
No, I have not.
Dr. Steinberger?
No.
Dr. Valku?
No.
Clinical therapist Peter Lowe?
No.
Thank you. Nothing further.
Mr. Welborn?
No questions.
Doctor excused or subject to recall?
Excuse is fine.
You're excused. Thank you, doctor.
Thank you very much.
Are we going to call another witness, or are we going to break?
I think we're break for the day, Your Honor.
All right, ladies